All right, take a look at question 6 from July of 2011, community property. And despite the long fact pattern, this is a real simple, very quick essay. If you haven't read the fact pattern, make sure you read it 2, 3, 4 times before you listen to this. So feel free to hit pause, and we'll get into it in a second. Because you have to be familiar with it, so when I go through it, it just makes complete sense. Okay, upon dissolution of marriage, don't forget, always go to the call to question so you know what you're doing. What are Wendy and Hank's respective rights and liabilities with respect to, number 1, the car. Number 2, the $30,000 additional salary. Well, to me, that already smells like community property because they use the word salary. The $50,000 owed to the casino. Here's a little tip to casino. Looks like this is a debt. Someone's been gambling. Probably didn't have the Warriors last night. Congratulations to Steph, 2-time MVP. Okay, this is answer according to California law. When they say answer according to California law, very few subjects are California specific. California wills, California community property. That's the ones you're most likely going to see answered according to California law. There is California evidence. I'd probably say answer according to the California Evidence Code. I forgot what it says actually now. I believe it says that. Or use the California Rules of Evidence. And then there's California Civil Procedure. Okay, so let's take a look at from the top. And notice it starts in 2003. The second paragraph also in 2003. Then 2006, 2008, 2009. So again, it goes in chronological order. This is a very common theme in a wills and community property essays. 2003, Wendy and Hank were engaged to be married. They're not married yet. They discovered that the $10,000 monthly income Wendy derived from a trust fund would terminate upon her marriage or upon her reaching the age of 25, whichever came first. Therefore, they decided to postpone their wedding until Wendy's 25th birthday in 2006 and began to live together. Well, we have 2 people that are living together that aren't married. Some religious people would have different names for them, but I call them unmarried cohabitants because that's what they are. They don't have any community property rights, but they may have contract rights under Marvin contract principles. I might be jumping the gun a little bit here. You're like, how did I come up with that? I haven't come up with it yet. I'm assuming you've read the fact pattern a few times, and you'll see how she can claim a right to the car. Also in 2003, Wendy and Hank agreed, so they have some kind of agreement. It could be a tacit agreement. It doesn't have to be written. It could be implied that Wendy would pursue a master's degree in education. And don't forget, an educational debt is separate property because there's no way to split it. It's your JD. You can't inherit it. You can't give it to somebody. You can't transfer it. And it's very hard to value. Hank would quit his job and stay home, taking care of the household chores. So he's relying on an agreement that they have. Now, granted, Marvin contracts are incredibly hard to prove, but the examiners are giving you the facts here that make it pretty easy to prove, but in real life, they're extremely hard to prove. So we have an agreement to share property. What are they going to share? They're going to share her trust fund. And he relied on it by staying home. Quitting his job. Very similar to the Marvin Michelle Truvioli case, ironically. She quit her career as a potential actress to help him focus on his career, take care of his home and stuff like that. She ended up losing, I believe, because the court wasn't able, she had also slept with other men in the process. The court found that there was no agreement. But the principle came out of it. They said there could be an agreement. It's just I don't think she was able to prove it to the point that the court was convinced that they agreed to share property, that he was going to agree. He was agreeing her, like, hey, it's quid pro quo. You quit your job, you quit your career, you come live with me, and I'll take care of you, and I promise you. So that's a contract thing, very hard to prove. If you don't want it to be proven, if you're living with someone right now, don't put it in writing. I'll tell you that right now. So it's an agreement to share property. They're sharing the money from the trust fund. He relied on it by staying home, quitting his job. Said Wendy opened a checking account in both their names in which she deposited the monthly income. Again, that joint account is proof that they have some kind of agreement to share the money, because now it's halfway in his name. If I was him, first thing I would do is take the money out and go to the casino. Whoops, he already did that. Okay. So Wendy used the funds in the checking to pay for living expenses for Hank and herself. Again, showing an intent to take care of him, that there's an agreement that they would share the money. Wendy also used the funds in the checking account to buy a car. She put title in both their names. Again, title to the car, both names. And don't forget, when spouses put title in both names, when it's jointly titled property, there's a presumption that it's community property. I mean, you can only have an express written declaration saying otherwise, but she doesn't have that. So the car is going to be, it's not community property, it's going to be split equally because technically they're not married and they just have equal rights with respect to the car under what would be like a contract principle. So ironically, it's community property / contracts, but contracts are included in community property under the Marvin principles. Okay, so those first two paragraphs, despite all those facts, had one very simple issue. 2006, they finally married. So now they have community property rights. Wendy's $10,000 must trust income terminated. She began teaching at a local college. And now teaching is labor, salary, equals community property. So any money she earns while they're married at the college is community property. 2008, Wendy learned that her compensation was less than the male counterparts and made a claim against the college. So she has the claim here. Now the cause of action arose when? During the marriage. Doesn't matter when it gets settled. It arose during the marriage, and you have to look at what her claim is intending to replace. Is it for future income or future benefits or future employment, or is it for past services? Well, for 2 years, she's been paid less. She's suing because she's been paid less for those 2 years, so it goes to past services, which means it's community property. The community is going to have an interest in it. This is not to replace future income. This is to reward her or compensate her for past services, obviously for money that she got less between 2006 to 2008. 2009, Wendy separated from Hank and filed an action for dissolution. Okay, so when does the economic marital community end? And it ends when you move out, no intent to resume. These two things must be satisfied in order for it to be the end of the economic marital community. Well, it says here, she separated from Hank and filed an action for dissolution. Filing an action for dissolution is strong evidence of an intent not to resume, and assuming that they moved out, I'm not quite sure. It said she separated from him. Let's just assume they move out. I mean, you can't make a big deal out of it. You just say, if she did move out, end of the economic marital community in 2009. But if she didn't move out, then it continues, because she must move out in order to end the economic marital community, or her paltry salary at the local college is going to be split. Shortly afterwards, she settled her claim against the college in return for additional salary in the amount of $10,000 per year for the next 3 years. Aha! So is this, like I said, is the $10,000 intended to compensate her for past services or future income? Because don't forget, she settled it after they had moved out and they had no intent to resume. But just because she settled it afterwards doesn't mean it's separate property. It has to do with when the cause of action arose, and it arose during the marriage. Now, because it arose during the marriage, it's presumptively community property. However, is this money intended to replace past services or future earnings? If it's future earnings, and I don't know what the answer is because there is no answer. We don't technically know. We need witnesses. We need testimony. We need the judge to be able to hear what this is. I mean, in one regard, it's compensation for what she didn't get paid from 2006 to 2008. In the other regard, it's an additional salary of $10,000 per year for the next 3 years. Well, I think you have a great argument for past services because between 2006 to 2009, she got paid less. That's 3 years, and they're only paying her the $10,000 for the 3 years. I think the better argument is past services, community property, even though it's going to get paid in the future. Hank has a right to the money, I think you would have I think in reality, future earnings would not take the day. I think the judge would rule it's passed. Unbeknownst to Wendy, Hank had run up a gambling debt to a casino during their marriage. Okay, so we don't know when, during their marriage. So the $50,000 at the casino, it said during the marriage. So debts during the marriage. And of course, the debtor, which is H, his separate property, is going to be available. I mean, his separate property is going to be liable for it. And then let's see here. So he owed him $50,000. So when the debt is incurred during the marriage, all the debtor's separate properties and all the community property is liable. So we know that Hank's separate property is, because it was during the marriage, the community property is also liable. Of course, her separate property is not liable unless it was for necessities, but I think you're going to have a hard time saying that gambling is a necessity. Clearly, it's not defined as a necessity. So because he ran up the debt during their marriage, it's all of his separate properties on the hook and all the community property is liable, but Wendy's separate property is not liable. Also, the court's likely to assign this debt solely to Hank because it was not for the benefit of the community, so it's going to be assigned to the spouse who incurred the debt. So the debt's likely going to have to be strictly Hank's. His separate property and all the community property is liable. She'll end up paying for it, actually, with her salary. And there you go. That's the money that goes to the casino. I think the call to question said, what are their rights to the money owed? Well, the community property is liable and his separate property is liable. Okay, upon dissolution, what are Wendy and Hank's rights and liabilities with respect to the car? Again, they weren't married at the time. They were unmarried cohabitants. They had an agreement to share property. Her conduct clearly shows that by putting a bank account in both their names, title of the car in both their names, which creates a presumption that it's community property. It was, he relied on what she said by quitting his job, and we all know in contracts, reliance is enough consideration to support the contract. So based on Marvin contract principles, the car is going to be split equally. The $30,000 additional salary, well, labor, teaching, skill, that's effort, that's community property. The cause of action arose during the marriage. It's community property, even though it was paid after the marriage. The cause of action arose during it. The cause of action was between 2006 to 2009, which technically looks like it's to replace past services, not future earnings, which would be separate property. Past services are community property, and therefore, Hank would have a right to half of the $30,000. He gets $15,000. And for the casino, that happened during the marriage. So Hank's separate property is on the hook. And of course, all the community property is, but not Wendy's separate property. And that's it. For a long fact pattern, very simple essay with almost no issues. I mean, 4 issues. But then again, I'll give you a little tip. Question 6 tends to be pretty much of an easier essay. Well, you can't use that rule of thumb all the time. But whenever I see a real short answer, I'm like, that must be question 1 or question 6. It's kind of what the examiners tend to do. Don't write that in stone. It is what it is. Know these principles, understand the law, and you'll kick ass in the bar. Thanks a lot.